So, where do you draw the line? I mean, when does sophisticated detective work cross over into something else entirely?
You mean into creating a crime?
Exactly, into creating the very criminal activity that law enforcement is supposed to be preventing. It is one of the trickiest legal puzzles out there. Today, we're doing a deep dive into the defense that's meant to protect, well, the person the courts call the unwary innocent. We're talking about the doctrine of entrapment.
Yeah.
Our mission is to figure out how the Supreme Court draws that really fine line between acceptable police stealth and strategy on one hand and the outright manufacturing of crime on the other. And we're going to use the landmark 1958 case, Sherman versus United States, to really map out the analysis.
And Sherman is a perfect source for this. It gives us a fantastic model for understanding the federal standard, which is what we call the subjective doctrine of entrapment.
Subjective, meaning it's about the person's state of mind.
Precisely. The whole focus shifts away from the police conduct itself and squarely onto the defendant's mind. And to really master this, you have to break down the two key elements that make or break the entire defense: government inducement and defendant predisposition.
Okay, so before we get into the weeds on Mr. Sherman's case, let's zoom out. What's the fundamental policy here? I mean, what's the ethical reason for even having this defense in the federal system at all?
Well, it all comes down to a really basic question about government. What is the purpose of law enforcement?
To prevent crime, right. Apprehend criminals who are already out there.
Exactly. Their function is not, and was never intended to be, the manufacturing of new crime. The courts basically said that Congress couldn't have intended for criminal laws to be enforced by, tricking or tempting otherwise innocent people into breaking them. So the general rule, which really builds on an earlier case called Sorrells, is that entrapment only happens if the criminal act was, and this is the key phrase, the product of the creative activity of law enforcement.
It's a creative activity.
Yes. The idea for the crime has to originate with the government, and then they have to go and implant in the mind of an innocent person the disposition to commit the alleged offense.
So that really sets up the core conflict. The court is basically trying to find the origin story of the crime. So what are the two specific elements we need to analyze to see if the government went too far?
The court conducts what they call a searching inquiry. It's a two-step process. First, inducement.
Okay.
Did the government or its agent actually induce the person to commit the crime? Was it more than just, say, giving them an opportunity?
And the second part.
Predisposition. You have to ask. Was this person an otherwise unwilling individual, the unwary innocent, or were they already an unwary criminal, just, waiting for the chance?
That distinction seems to be everything. Okay, let's apply this framework to the man at the center of it all, Joseph Sherman. We need to model this analysis very precisely. So let's analyze Sherman v. United States. First, what are the legally dispositive facts?
Well, the essential story is one of shared vulnerability, really. It's 1951, and Joseph Sherman meets this other man, Calchinian, who, unbeknownst to Sherman, is an unpaid government informer.
And where do they meet?
At a doctor's office. Both of them are there seeking treatment for narcotics addiction. And this is key. Calchinian starts repeatedly, persistently, approaching Sherman. He tells him he's suffering, that the treatment isn't working, and he begs Sherman to find him a source of narcotics.
And Sherman's reaction?
He says no at first. He tries to avoid the subject entirely. But Calchinian keeps at it, really playing on this shared struggle, this appeal to sympathy. And eventually Sherman gives in, he gets narcotics, shares them a few times, and only asks for his costs plus taxi fare back.
Wow.
And after that, Calchinian reports it all to federal agents, who then observe 3 more sales, and that's what leads to Sherman's arrest.
So with that background, what was the core legal issue that made its way up to the Supreme Court?
The precise question was this. Based only on the undisputed testimony from the prosecution's own witness, the informer Calchinian himself, was entrapment established as a matter of law? And if so, did the conviction have to be thrown out?
Okay. What rule of law did the court apply? Can you state the full doctrine and break it down into its testable elements for us?
Of course. The court applied that same subjective test for entrapment we just talked about. They reiterated that the law's job is to draw a line between the trap for the unwary innocent and the trap for the unwary criminal.
And the rule itself?
The rule is whether the criminal conduct was the product of the creative activity of officials. And that breaks down into the 2 elements we have to analyze one by one. First, government inducement, and second, a lack of defendant predisposition.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, inducement.
The court said inducement was patently clear. I mean, it wasn't even a close call. And that conclusion came directly from Kalchinian's own testimony.
He admitted it himself.
He did. He admitted to using emotional coercion, to playing on their shared addiction and suffering, a direct appeal to sympathy to get what he wanted. And crucially, Sherman's initial refusal proved that one request wasn't enough. It took additional, persistent requests to get him to give in. This was aggressive, targeted persuasion. So the court concluded, inducement was met.
Understood. Inducement established. So the government definitely had a hand in creating the crime. But their whole case then hinges on that second element, arguing that Sherman already had a ready complacence. So what about the second element, predisposition? How did the court analyze that?
Right, so the government's argument was basically, look, he did it, so he must have been ready to do it.
Yeah.
The court just completely rejected that logic. They demanded specific evidence of his readiness before the government got involved.
And what did they find?
Well, first they noted there was zero evidence Sherman was currently a drug dealer. They searched his apartment, found no narcotics, and saw he wasn't making any real profit, just covering costs.
Okay, what about his criminal record?
That was the government's big play. They pointed to a 1942 sale conviction and a 1946 possession conviction. But the court did something really important here. It said that evidence was too remote. 9 years and 5 years ago was too long in the past, especially because all the current evidence showed Sherman was actively trying to get clean in 1951. Therefore, the court concluded the government completely failed to prove he had the necessary predisposition.
And after analyzing all the elements, inducement was clear, predisposition was not proven. What was the court's final conclusion?
The court reversed the conviction and ordered the whole indictment dismissed. The analysis proved, really beyond a doubt, that the government had manufactured a crime against someone who was trying to overcome his addiction. It's a powerful ruling that protects the unwary from being beguiled into committing crimes which he otherwise would not have attempted.
Okay, so this is where it gets really fascinating. The case shows that playing on sympathy and exploiting a medical condition is clear inducement. So what if a government agent just walks up to someone and says, "Hey, I hear you sell illegal prescription drugs. Want to make a deal?" Why isn't that inducement under the Sherman rule?
Because that's the very bright line the court draws between inducement and just affording an opportunity.
Just opening a door.
Exactly. Merely providing an opportunity is legally neutral. If you immediately say yes to that agent, then by definition, the disposition to commit that crime was already in your mind. You were the unwary criminal they're allowed to catch.
But let's change it. What if an undercover agent knows a target just lost their job and is desperate for money? The agent goes up to them crying and says, "My mother will be deported and die if I don't get this rare medicine for her. You're my only hope," and then offers 10 times the street value. Now what?
Now you're in a completely different world. That is textbook inducement under Sherman.
Because it's not just an opportunity anymore.
Not at all. The agent is using aggressive persuasion. They're playing on compassion, they're exploiting a known financial weakness, and they're using excessive profit as bait. That's a perfect example of the exact evil the Sherman court wanted to prevent, government methods that deliberately play on the weaknesses of an innocent party just to create a crime.
That makes the distinction incredibly sharp. Opportunity versus emotional coercion. Okay, for everyone listening who needs to apply this doctrine, let's synthesize this. Can you give us an actionable 4-step diagnostic checklist?
Absolutely.
Yeah.
This is the blueprint for how you break it down. When you see a fact pattern with an agent tempting a target, here's what you do.
Step 1.
Step 1. Identify the government actor. Was the person doing the inducing an official agent, a police officer, or, and this is crucial, an active government informer like Kalchinian? Because the government is on the hook for their actions.
Okay, that makes sense. Then step 2.
Step 2. Analyze inducement. Was the government's conduct more than just offering a chance? You look for specific tactics, repeated requests, appeals to specific vulnerabilities like sympathy or addiction, coercion. If you see those, inducement is almost certainly met.
Right. And after inducement, you move to the government side of the argument.
Step 3. Analyze predisposition. This is where the government tries to save its case. Did the person already have a ready complacence before the government showed up? Scrutinize the evidence. Are the prior convictions too old and stale, like in Sherman? Was the defendant actually in the business making a profit? If they were reluctant, like Sherman was, predisposition is lacking.
And finally, you put it all together.
Step 4. Synthesize and conclude. It's simple. If the defense shows that inducement happened, and each side of the government fails to prove predisposition beyond a reasonable doubt, the defense wins. The case has to be dismissed.
The impact of Sherman is just, it's so profound. It says that law enforcement can't just be a criminal creative agency, and it forces courts to conduct that searching inquiry into a defendant's current state of mind, not just rely on assumptions or, old history. So what does this all leave us with? The Sherman court drew a line at 5 and 9-year-old convictions. If the government is barred from using stale evidence of addiction to prove someone is predisposed to commit a crime today, how far back should the law let them look? That ethical boundary of historical relevance, that remains the toughest question for this subjective test even now.